juror interview of juror interview number 1. Please state your name for the record.
My name's Layla Czirok.
All right. And this is about case number 2, private practice, revised policies and procedures addressing activities preparatorial to research. The defendant here is a Dr. Joanne Sebastian Clinical and her private practice. It looks here to be about the plaintiff is several patients who were phoned for research that selected one student who represented them all and can use real names. And the issue here, it looks like impermissible disclosure research. Juror 1, could you please, if you would, explain maybe a little bit more in detail about what happened during the trials in maybe your own words?
Well, basically what happened was this research that was done, it was done by Dr. Clinician, wanted to do research on cancer patients, had asked for all these patients to fill out a consent form, getting their permission, and explained in perfect detail, made sure everybody understood what was happening, and then letting them know that they would have a researcher give them a call, to let them, ask certain questions. And of course, all these patients had signed these consent forms and willingly stating that they understood. But for whatever reason, they're filing a suit because they feel that certain things were violated. Obviously, there was something that they didn't understand when they did fill out the consent form, even though they said they did. Some of those violations that the plaintiff believes that has happened is there's been a HIPAA violation, a common law right to privacy violation, and a privacy rule violation.
Could you go into more detail about some of those violations, please?
Yes, absolutely.
Thank you.
The HIPAA is basically a private rule that provides federal protection for individuals' identifiable health information that's held and by covered information. At the same time, this privacy rule is balanced so that it permits the disclosure of health information needed for patient care and other important purposes. Now, the common law right to privacy is the right of the person to be let alone, to be free from unwarranted publicity, living without unwarranted interference by the public, and in matters in which the public is not necessarily concerned, and it's an actionable, invasive of the right of privacy. That is unwarranted, inappropriate exploitation of the person's personality, publicizing of one's private affairs with which the public has no legitimate concern, and it's wrongful intrusion into one's private activities in such a manner that could be outraged or cause mental suffering, shame, humiliation to a patient of ordinary sensibility. The private rule is where the individual has the expectation to keep or less control access to his or her individual space, as well as knowledge of certain information. What legally falls under the zone of privacy often varies in depending on jurisdiction or the content and the expectation of the privacy. They can also vary by person, content, or culture. Now, as for the defendant side, they'd gotten the complainant or the plaintiff to sign the informed consent form, which is a release for information purposes. Now, an informed consent is the idea or notion that the healthcare decision should be made in collaboration in manner between a patient and a physician or a healthcare team. It is also an ethical doctrine that has set legal rules and prescribes certain behaviors and procedures that a healthcare profession would provide.
So in a sense, you're saying that basically that they can't be released to a third party that isn't part of said medical team or something?
If it's in the consent form, it actually can.
Oh, okay.
Only if it's put in the consent form. If not, if it's something that's between the patient and the doctor or healthcare team, then yes, that would be. But in this case, this was actually doing a research on cancer patients. And this research did include a third party in this consent form. So of course, with this consent form, it does require, 5 requirements that are necessary for a consent form. And those 5 requirements are adequate disclosure of information, decisional capability or capacity of the patient's comprehension of the information, voluntariness, which is freedom from being coerced, and then of course the consent of the patient. And then which the defendant, they had met all those requirements, and it also showed that they had proof that the plaintiffs have actually signed the consent form stating that they understood what they were signing. So my personal opinion, I do believe that the defendant is not guilty. And that's the conclusion I've come to.
Okay, thank you for your time.
Thanks.